What is going on? They said it's showtime. Today is September 7th. We're in September now. Wow, time is flying. September 7th, 2025. We are back with another live show. I am your host, Dave, a 10-plus year intellectual property attorney. And man, the good thing is football season is back. So now you got the roller coasters of the losses and the wins. My Michigan State Spartans won yesterday. They beat Boston College. For those of you who don't know, you see the jersey in the background. I am a double Spartan. I went to undergrad at Michigan State University, played football there as well as went to law school there. So I'm a double Spartan. And I'm jacked that we beat Boston College yesterday. Got the revenge. Last year we lost to them in Boston. But the Lions just lost. So that's what I talk about when I talk about the roller coaster ride of football season. You get the wins, you get the losses, and you kind of try to have to navigate it all. So like I said, the Lions just lost, so kind of feeling that a little bit, but Michigan State won. So I will kind of still rejoice in that victory from yesterday. So we got another good Saturday or Sunday night game, rather, between Buffalo Bills and Baltimore Ravens. And that should be a good one. So I'm not going to hold you guys up for too long, but please, please, please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. We got a full show for you guys lined up here. We're going to be talking about the Buy It Now episode of the week, Anthropic. Now, I've been talking about this Anthropic versus 500,000 authors, and it seems like they have agreed to pay the authors $1.5 billion. So we'll look at that. It looks like Ohio State and Michigan, talking about football season. Ohio State and Michigan are back at it off the gridiron, this time in a trademark lawsuit. We'll be going over the interview of the week with Mixxtape, and I actually got that to be talking about here. He sent me one, Paul Barnes, so shout out to Paul Barnes. We'll be talking about that. Penn State. Again, it's crazy. We're talking about Michigan. We're talking about Ohio State. We're talking about Penn State. I should have named the name of this show the Big Ten battles. But Penn State, it seems like it's something going on with that, with the trademark name for the kids of all names. And then we'll be kind of finishing off with OPENAI, some good learning lessons from that one, as well as Nerds. The Candy Nerds has sued a competitor for trademark infringement. That's the lawsuit of the week that we will be going through and reading in real time. So that's the lineup for today. Please hit that like button for the YouTube algorithm. Let me adjust my camera here a little bit so I can make sure I'm getting all. There we go. There we go. I like that. I like that. We're going to start off with the good stuff. And when I say the good stuff, I'm talking about the Buy It Now episode of the week. Shout out to Khadijah. She's out in Philadelphia, Pennsylvania. And I do want to bring up her product, which is called Aqua headwear. Now, we all know that Nick Cannon is wearing the turbans these days, and it seems like this Aqua headwear is a turban that is waterproof. So you can get in the shower with it. It's a stylish cap that you can wear outside in the rain. So the ladies, or the fellas for that matter, don't have to worry about getting your hair wet while still looking stylish. So she was just recently, well, I want to say recently, but I had kind of broke down episode 9 of Buy It Now, which is kind of almost competitors to Shark Tank. I like it a little bit better. I don't want to say I like it better, but it's different in the sense that it's more of a game show. So you pitch in front of a live audience of 100. You got to have, 10 out of the 100 to say they will buy the product to go on to the panel of 3. Then if 2 out of the 3 panel members say they like the product, then you go into Amazon's exclusive Buy It Now store. And Khadijah, she has a product, Aqua headwear, that was phenomenal. So her pitch was amazing, and she seems like she's killing the game. Some notes. Seems like she's has 2 full-time jobs in addition to her product, Aqua headwear, which is one of the reasons why I did want to talk about her product, man. Sometimes you got to grind this out. You have a Khadijah, a hustler out in Philadelphia, Pennsylvania, 2 full-time jobs. She talked about working from 6 to 3 in the morning on her product, Aqua headwear, which again is a turban headwear. So definitely go check out that pitch that I did, as well as go purchase the product. Seems like it's a phenomenal product. She has made $200,000 so far on it, and I think she's invested around $80,000. So shouts out to Khadijah. I'm going to reach out to Khadijah, man, see if I can get on the platform. I love what she's doing over there at Aqua headwear. So again, let's continue on with this Buy It Now theme and get off into the interview of the week. To the extent that somebody you watching, you have a question for me, this is probably the only time this week, maybe this month rather, that you'll be talking to intellectual property attorney specializing in trademarks, patents. So definitely put your question if you have a question in the chat, and I will get around to it. Again, your boy billing rate is almost $400. So anytime you can ask a IP attorney a question for free, you definitely want to take advantage of that. So definitely, to the extent that you have a question, leave that in the chat and I will get to it. I will say too, man, just let me know where you're from. If you're seeing this for the first time or you're a regular, shout out where you're from, shout out your name, man. Show your boy some love. So with that being said, let's get off into Mixxtape. So this was the interview of the week. And Paul Burns, I'm gonna play it here in a little bit, but he sent me one of these things, which is super dope. For all you old heads, you know what this is. For you young heads, I grew up in the 90s, early 2000s, and even though I caught the cassette tape, my era was really the CDs. However, Paul Burns has invented this cassette tape that doubles as an MP3 player. So you can put it in a tape player, you can download songs to it, put it in a tape player, and it will play on that. Or to the extent that you are in an airport or whatever the case may be, you can use it as an MP3 player. You see, it's touchscreen, so you have the touchscreen there that you can download the songs to it. Let me see if it comes on here. So, man, this is a really dope product. Thankfully, Paul Burns sent me one. I'm gonna pull up his interview here in a second, so we're gonna go through his interview. But man, you see the touchscreen here. Again, this is a cassette tape reinvented. So it's a cassette tape that doubles as an MP3 player. You see the headphones that actually comes with this thing. He sent this all to me. Thankfully, man, your boy, I love what I do because sometimes I get these gifts for free. And Paul Burns, he was able to get this thing, send this to me for free. So let's pull up the website of what Paul was talking about. I mean, not the website, but let's pull up the interview of what Paul was talking about. Man, go check out that full interview here. I'm gonna play a snippet. I'm gonna play a snippet here, man. Let me know if you guys are some Lions fans, man. We licking our wounds after that game that the Lions just put together versus the Green Bay Packers, but we're gonna still try to get through the show here. So Mixxtape, your boy Paul Burns. Let's see what he's talking about, and then I kind of give you guys my comments. Just kind of play a snippet from the interview. Let's go.
The original inspiration was I have a lot of friends that are in the music industry, some successful, some not, and I was trying to come up with a way that would help them get noticed. And so I was coming up with a bunch of different like MP3 player designs.
That's the word I'm using for MP3.
Yeah, like MP3 player, and I just kept going back to the cassette, and then I looked out there, and there were like some adapters and this, that, and the other, but nothing like what I was envisioning. So I'm like, okay, I'm going to figure out a way to make this. And so I ended up basically taking apart like MP3 players and the old cassette adapters that you used to put in your car that had the wire that came out so you could play it into your CD player.
I remember those, yeah.
So like taking those apart and just trying to figure out like, how does this work?
Kind of stop this and bring it back on myself, man. He invented what he's calling Mixxtape, which is the cassette tape reimagined or reinvented, I should say. He sent me a version for free. You see the power button here. You got the power button. You got the headphone jack here that it comes with the headphones when you purchase it. Put your headphones in there. You can download over 2,000 songs on this thing. So to the extent that you kind of want to use it as a MP3 player, you can use it. You see the touch screen there. But if you're an old head or a new head for that matter and never use a cassette tape, you can put this thing in a cassette player and use it and play it as well. So, man, shout out to Paul Burns and Mixxtape, man. I love what he's doing. Go check out that interview. It was a pretty dope interview. So let's kind of continue keeping it moving along here. We're going to talk about Michigan and Ohio State. Now, it seems like it was a bar fight. And I want to pull this up here really quickly, and we are going to go through what happened between Michigan is what Ohio State sued a Michigan bar. I should say, just kind of be correct. Let's see here. Okay, here we go. So the University of Ohio State, let me give you, before I pull up the news article or the news video, we're going to play that. It seems like a Michigan bar in Ann Arbor has a beer called Buckeye Tears. You can see kind of the beer. This is actually a real can of the beer that I have in the picture to the left. It's called Buckeye Tears. Now, if you're in Ann Arbor or if you're a Michigan fan or football fan, I should say, you know what Buckeye Tears mean. It's a play on Ohio State University and the fact that they're called the Buckeyes, and Buckeye Tears mean Ohio State Buckeyes crying. So, they look to trademark the term Buckeye Tears and have an actual beer in an Ann Arbor restaurant called Buckeye Tears. In Ohio State, the Ohio State University, it seemed to not take too kind to that and actually sued not the University of Michigan, but they sued the bar in Ann Arbor for trademark infringement. So that's essentially kind of what's going on here. Let's kind of look at the news article of, I'm not sure if this is a newscasting in Ann Arbor or what, but let's play the news article and I'm gonna kind of tell you guys my thoughts on this. Let's go.
Rick Mesher, who is a trademark and patent attorney with Porter Wright here in Columbus. And Rick, as we know, yesterday, the Ohio State University got a trademark on the word "the," and people hear that and they say, that is the most common word in the English language. How is it that someone can get a trademark on
I don't care about the trademark on a word. Let's get to the real stuff.
Word or logos. So in this particular case, OSU has the right to use the athletics, even all of Apple, all kinds of, they have many registrations, zone, headwear. So since their rights are limited to that.
So why do they need it then?
Man, I don't like that one, man. That's not the one I was looking for. Let's see here. We gotta, that wasn't the one I was looking for. So I'm not sure why that one pulled up, but give me a second here. Michigan from the Buckeye Tears. I'm not sure why this was the right one. This was the right one. How my stuff is going to, let's go back. We're doing this in real time. Sometimes, man, this stuff don't want to, here we go. This is the one. Let's go to this one. We pulled up the right one, man. Sometimes why is it talking about that one? I don't care about that one. Why is it talking about the "the"?
They say that is the most common word in the English.
I don't care about that one.
Registration, its purpose is to prevent consumer confusion, right? So that's why they get the exclusive right to use "the" on hats and T-shirts, because if another school starts that all has "the,"
I don't care about that one.
Ohio State University.
And they really do. They have.
And they should have another one. I was just listening to this. Is this the one? This may be it. This may be the video. Maybe I have to break it down without the newscasting. Or the Buckeye Tears, the drink, the beer in an Ann Arbor restaurant called Buckeye Tears. Is it gonna play it here, or do I have to break it down without the actual news video? Let's see here. Looks like it's taking a little bit longer to load. I'm gonna just break it down without the video here. So essentially what happened was, that's pretty frustrating. So essentially what happened was the Michigan restaurant or bar trademarked the term Buckeye Tears for their beer. And they actually have a beer called the Buckeye Tears. The Ohio State University did not like that. And I think that Michigan bar actually, they have the trademark. So the USPTO allowed them to register the term Buckeye Tears. The University of Ohio State, the Ohio State University did not like that and sued the restaurant for trademark infringement. And it's an ongoing thing. Now, if I got you guys my 10 cents as a 10+ year intellectual property attorney, I think the Michigan bar is in good shape here. Number one, Ohio State is not the only term, not the only right holder or the trademark holder of Buckeye. It's a ton of Buckeye trademarks that out there for various things, whether it's athletics, whether it's entertainment services, so forth and so on. So the fact that it's a lot of trademarks out there for the term Buckeye, I think is ultimately going to hurt the Ohio State University's claim of trademark infringement against the Ann Arbor restaurant. That's number one. And then number two, again, they got the trademark from the USPTO, so there's a presumption of validity that way. And it's not like, the USPTO thought it was a likelihood of infringement there. So those are the two things that I think that now if they were calling it the Ohio State University Buckeyes, that was the name of the beer, then I do think that Ohio State University will have a stronger claim. But the fact that the Ann Arbor restaurant is calling their beer Buckeye Tears, I don't think this is trademark infringement. Like I said, Ohio State is not the only, they're not the exclusive trademark holder for the term Buckeye. And the fact that the Ann Arbor restaurant avoided the term Ohio State University in their trademark, I do think that the Ann Arbor restaurant is going to be okay with regard to, in my opinion, this is my opinion, they're going to be okay with regard to their kind of trademark infringement lawsuit against the Ohio State University. But I'll kind of keep you guys abreast and see what happens, whether or not they end up settling, whether or not the the Ann Arbor restaurant has to change their the name of their beer from Buckeye Tears to something else. I kind of keep you guys apprised of that. So that's what's going on between Ohio State University and the Ann Arbor restaurant and their beer called the Buckeye Tears. So let's kind of move on here to Anthropic. And I've been kind of talking about this one for a while. Now, Anthropic is an AI company, and apparently this AI company, and we're going to play the video here, they've been around for 4 years. And it seems like, they're training all their AI models, and I'm giving you guys a kind of a lay of the land before I pull up the video, but they're training all their AI models to essentially by using authors' books. And the authors didn't like that. They filed a copyright infringement claim against the AI company Anthropic. And the district court, I think it was out in California, actually ruled in favor of Anthropic to say, hey, you can actually purchase somebody's copyrights or purchase somebody's book and use that to train your AI models. Now, what the court did say that you can't pirate it or you can't essentially steal it or illegally download it and train it. And I think that's what Anthropic kind of was on the hook for. And it seems like as a result of that, they settled with the authors. I think it was like 500,000 authors that they settled with, and they agreed to pay the authors $1.5 billion. Now, I want you guys to let me know who wins in this situation. Does Anthropic, and the fact that, man, these AI companies making bread, the fact that you're an AI company that's been around for 4 years, you have agreed to pay $1.5 billion to authors, that means that you getting some money. But who actually wins? Do you think it's the AI company Anthropic? Do you think it's the authors, or do you think it's somebody else? I'm going to let you know who I think wins, but to the extent that you're in the comment, watching this, I want you to let me know who do you think win this lawsuit? Is it the authors? Is it the AI company Anthropic, or is it somebody else? I'm gonna give you guys a couple of seconds while I pull this up, and I'm gonna let you know who I think wins in this actual lawsuit. And it's probably somebody that you guys will not think about, but I'm gonna let you know who I think is winning in this actual lawsuit. And who I think wins in this actual lawsuit is the attorneys. Man, these attorneys typically, when they take these, especially these class action lawsuits, they are taking it on contingency fee, which means that a lot of times they get 30% or 33% of the third of it. So if Anthropic agreed to pay these authors $1.5 billion, then that means the attorneys could make up to $500 million. So again, Anthropic, I think the $1.5 billion, they cool with handing that over. The authors, man, again, 500,000 at the 1.5 million. That means that 1.5 billion. That means the authors only got $3,000 each. But I think the real winners of this lawsuit is the attorneys, unfortunately. So let's kind of pull up the news article and let's see what they say here.
We are getting some news on Anthropic.
This one. Let's go.
Mackenzie Segalos is that for us. Hey, Mac.
Hey, Leslie. So there is a new filing in the class action lawsuit against Anthropic. They are going to pay $1.5 billion to settle a copyright case that was brought by authors who said that the AI startup downloaded millions of pirated books. Now, the company had faced the risk of more than $1 trillion in damages if they didn't settle. A San Francisco judge.
Hey, you can almost make a case that Anthropic won, because if they were facing up to $1 trillion of damages, and they say, look, we're gonna settle out of court for $1.5 billion. You can say that was a win for Anthropic, but I think ultimately the attorneys win in this case by getting up to $500 million. But let's go.
Does still need to approve the deal. Anthropic's deputy general counsel telling me in a statement that this case established a key legal precedent, saying that in June, the district court issued a landmark ruling on AI development and copyright law, finding that Anthropic's approach to training AI models constitute fair use. Now, that is a big win for the AI industry, Leslie.
It's a pretty large amount for a 4-year-old company there. Mackenzie, thanks for staying on top of that for us. Mackenzie Sagalos.
And again, I agree with her, man. The 4-year-old company, and next thing you know, they're paying $1.5 billion. That lets you know how much these AI companies are getting, to the point where you can be in the game for 4 years or starting a business for 4 years and have agreed to pay $1.5 billion. Now, again, on their case, they avoid what she said, up to $1 trillion worth of damages that they would have had to pay potentially the authors. But even to agree to $1.5 billion when you are only 4 years old, that means that these AI companies are getting bread. So I did want to kind of give you guys that. Let's kind of move on to the next one, which is we're gonna go with Penn State. I almost named this thing the Big Ten battles. We had Ohio State, we had Michigan, now we have Penn State. Let's kind of play this news article. Seems like a Karen strikes again on this one. Trademark for the kids that it looked like Penn State was able to get. But let's see what the article says, and then I kind of give you guys my thoughts. Let's go.
Coverage you can count on. WGAL News 8 at 5:30 starts now.
At the end of the day, this is all about for the kids. What are we doing here? It's for the kid.
Tonight, a new.
So essentially, kind of before I play it, I do want to kind of give maybe a lay of the land. So it seems like Penn State, they've kind of been doing this nonprofit event for, I think, cancer research, if I'm not mistaken. And they've been doing this thing for like 20 years. And I think recently they filed for a trademark and got the trademark on For the Kids, a trademark called For the Kids, surrounding this charitable event. And it seems like it was a volunteer out of the University of Iowa complaining about, hey, everybody should be able to use the term For the Kids, even though Penn State had registered the trademark for it. So it seems like that's kind of what's going on. You always got that Karen where they kind of want to kind of stir up the dust on this one a little bit. That's essentially where we are. So let's kind of pull this up and see what the news says about it. Let's go.
Is a follow-up on Penn State's legal admission to let other organizations use the slogan they trademarked. One echoed often on campus, For the Kids, the official phrase of fun.
And tonight we are speaking with a lawyer who fought for the case pro bono and the precedent this trademark case sets moving forward. Thanks for staying with us here on News 8 at 5:30. I'm Lori Burkholder.
And I'm Jerry Gish. For the Kids has been the slogan for the annual dance marathon for years, being used since at least 1991, and even secured a trademark on the phrase in January of 2020 for jewelry, wristbands, apparel, and.
So again, they've been using this since 1991. Now I will say, man, if you've been using a mark since 1991, you probably want to get it trademarked a little sooner than 30 years later. They probably should have definitely tried to trademark it in 1991, but at least in the 90s. The fact that they waited 30 years or almost 30 years to 2020 to trademark the term For the Kids is a little bit crazy for me, but they did get it nonetheless. So let's go.
More, along with charitable service events.
But a former volunteer for the University of Iowa's dance marathon filed a dispute in 2023 saying that any organization raising money for childhood cancer treatment should be able to use it. That's when Rothwell Fig, a D.C. law firm, got involved.
There shouldn't be a registration for that term because it's not exclusive to any one entity. So,
man, I kind of agree with him, man, especially for charitable giving. And it seems like ultimately Penn State allowed the term to be used by anyone as long as it's for a particular use. I think it was charitable giving for a particular kind of cancer fundraiser they was doing in this case. But I kind of agree with them. For the kids, anytime you're doing a charitable event trying to raise money and you're doing it for kids, using the term For the Kids should be kind of available for everybody. So I kind of do agree with them on that term. But again, man, hey, when you're talking about business, it can be a dirty game.
the plan was just to knock that out.
Leo Laughlin represented Dr. Kaylee Tuttrow in her legal battle against Penn State. In the initial complaint, she says she engaged in and attended philanthropic events supporting children's hospitals and nonprofits using the phrase for the kids long before Penn State filed its trademark. She cited Iowa's dance marathon, which had promoted its event for years with For the Kids signs, slogans, and promotional materials.
The University of Iowa even wanted to rename a street near its children's hospital as For the Kids Way, but they need to change that to Hawkeye Wave Way in honor of the tradition of Iowa football games, where the crowd waves to patients across the street from the field.
And after years of negotiating and even a dismissal, eventually Penn State lawyers decided to settle the case.
There was some back and forth, but with licenses, there has to be certain things that are part of them. So there was some language back, there was some back and forth, but we came together an agreement. And that's what it is. So now Penn State's offering a royalty-free license to anyone that wishes to use the phrase For the Kids for charitable works for children.
And Rothwell Fig took the case pro bono, Latin for the public, essentially for free. When Newsday asked about why, he told us it was simple.
It's just something that's important to us, and not everything's about money. We should all be about that. And using this phrase has been used for a long time, as we pointed out, complained by various entities to raise money for kids. And our view is that should just continue without anybody having the right to deny others the right to use it.
Well, under the terms of the royalty-free license established by the resolution, philanthropic groups and nonprofit or charitable organizations can use the slogan only if they're using it to fundraise for medical research for pediatric patients. Any parties interested in using the slogan have to apply on Penn State's website.
So again, man, that's pretty much it. I think one of the interesting things that the lady mentioned that is worth noting that Penn State still owns the trademark. It's not like they canceled the trademark or the USPTO canceled the trademark, whatever the case may be. No, Penn State still owns a trademark. What they essentially said is, if you're raising money for, from a charitable standpoint for kids, then you can use you have to apply for the license, so they still have to grant you permission. But then you can use the mark, the trademark, without having to pay money to Penn State. So shouts out to Penn State. Shouts out to the attorney for taking the case pro bono and essentially getting to a good point where kind of Penn State was okay with it and his side was okay with it. But again, ultimately, this trademark stuff is still important because it's not like Penn State, the mark, they essentially gave back the mark or canceled the mark. They still own the mark. They just allow for other people to use it. But again, one of the things that wasn't talked about is Penn State has to agree for it. Now, they will agree. You got to apply for it. It's not like you just can do it willy-nilly. You have to apply for it, and Penn State essentially will grant you a royalty-free license as long as for charitable events or charitable fundraising for pediatric patients, in other words, for kids. So, again, shouts out to Penn State. Shouts out to the attorney. I think Rockwell Law or something like that they said for the philanthropic endeavor. And the stuff is important. So, man, let me know what you guys think about that. Did you guys think that it turned out nice? So essentially, if you're just joining us, Penn State registered the term For the Kids for charitable giving. And it seems like a University of Iowa professor did not like that. And she essentially got help from an attorney to challenge Penn State's trademark. And they essentially settled on Penn State essentially allowing others to use it if it's dealing with charitable giving and it's dealing with kids. So again, Penn State still owns the trademark, and people who are trying to use the trademark still have to get permission from Penn State. But to the extent that it's dealing with kids and charitable giving, Penn State is going to give you guys authorization to use the trademark term For the Kids for that. So let me know in the comments in the chat, did they get it right? Did they get it wrong? Do you think Penn State should not have agreed? Do you think they should have agreed? Let me know what you guys think in the comment section as we move on to the next part of this thing. And I think this one is a pretty interesting one. Now, this case was actually ruled on maybe like a month or so ago, but I think it's some important takeaways that I do want to highlight from this case. So OpenAI, and I think OpenAI is ran by Sam Altman, had a trademark victory, and it seems like it's some learning lessons in this one. So to kind of give you guys the lay of the land, it was another AI company who I think back in March of 2015 filed for a trademark, OpenAI, for it was for some particular use. I'm not sure the particular use. And the USPTO, March 2015, they got the domain name, the company, and they start they essentially got the domain name and they started the company. And then back when Sam Altman and OpenAI, as we know it, the OpenAI that owns ChatGPT, once they launched their company later on that year in 2015 in December, then you had the first company. You guys have to get these timelines correct. Once Sam Altman and the company that owned ChatGPT started back in December of 2015, the other company who started in March of 2015 filed for a trademark on the term OpenAI. Now, the company had already owned the domain name OpenAI, but they then filed for a trademark on the term OpenAI, and the USPTO denied them. It's a descriptive term, and they're not using it in commerce. So to combat that, what they did was the original company, I think it was called like Open Artificial Intelligence, they submitted a specimen, which pretty much showing that they're using the term in commerce, and they put it on a supplemental registrar. Now, a lot of people don't know about this supplemental registrar, but when you file for a trademark protection, it's pretty much, it goes on a principal registrar. But if it's deemed to be non-distinctive, then you can get it on the supplemental registrar, which you can still put the R in a circle. You can still sue somebody. However, it's not considered distinct as if the term was on the principal registrar. So again, the Open Artificial Intelligence Company, they submitted the specimen, they got it registered on the supplemental registrar. Then Sam Altman and the owner of ChatGPT, they end up filing for trademark infringement against the company to kind of dispute their trademark registration. And the court ruled in favor of Sam Altman and OpenAI that owns ChatGPT, saying that number one, the Open Artificial Intelligence Company submitted a bogus specimen. They weren't using it in commerce. So that's really one of the big takeaways. When you file for a trademark protection, before it registers, you got to let the USPTO know that you're using a mark in commerce, and we call that submitting a specimen. Now, once you submit that specimen, then your mark registers. But that specimen has to be a legit specimen. In this case, the guy submitted a bogus specimen, which came back to hunt him later down the line, and the court said, "Hey, you essentially submitted a fraudulent specimen." But then number two, you weren't using the term OpenAI in a way that Sam Altman and the owner of ChatGPT was using it. When you file for a trademark, and please listen, you have to let the USPTO know how you're using a trademark. So if you're, using it for entertainment services or a podcast, that does not automatically give you rights to use it for clothing, and kind of vice versa. So it seemed like in this case, the Open Artificial Intelligence, when they got their trademark registered on a supplemental registrar, number one, they submitted a bogus specimen would hurt them. Then number two, they were using it in a different way than ChatGPT and OpenAI that's owned by Sam Altman was using it. And that was even further evidenced by the fact that the guy tried to file for a trademark in that class similar to OpenAI later down the line, and the court was not having it. They essentially pulled the trademark from the guy and gave it to ChatGPT and OpenAI that's owned by Sam Altman. So the biggest takeaway in this case is, again, regardless if you have a business, you may not have patents, you may not have copyrights, but you should be at the very least protecting the business name by way of a trademark. I actually saw somebody back home who he has a vending machine company. He's killing the game. And I'm not going to say the name of it, but he's kind of showing it. He's kind of put in his new accounts. And I'm like, hey, man, make sure you protect the brand. Regardless if you got patents or whatever the case may be, you need to be protecting at the very least your brand name by way of a trademark. And I got actually some interesting products coming up that's going to help you do that. But kind of getting back to this case, you need to be at least protecting your brand name. And to the extent that you're protecting your brand name, you need to submit a correct and accurate specimen showing how you're using this mark in commerce. You can submit a bogus specimen if you want to, but you better believe that can come back and bite you. And as a result of it biting you, the court can't take your trademark. So make sure you're submitting an accurate specimen, and you're submitting that accurate specimen based on the classes that you are currently using that trademark in. Hopefully you guys understand that. I did want to bring that up. Let me know if you have any questions to that in the chat. Or you have any other questions, let me know in the chat. We're going to move on to the last case of the day. The lawsuit is, we all like nerds. Your boy haven't had any nerds in a long time, but it seems like the company who owns the candy Nerds is suing a company that just recently started selling the candy called Dweebs. Now, as you can see from the picture down in the left, the Dweebs candy looks very similar to the Nerds. And to be honest with you, It seems like the company, and I'm gonna pull up a lawsuit and read it here. But did you guys know? Please let me know this in the chat. Did you know that the company who started Nerds also had a candy called Dweebs? Seems like that was discontinued in the 90s. But I did not know that. I'm a 90s baby. But I did not know, obviously we all know Nerds, but I did not know that the company that started Nerds, it was also a company, also a candy that was called Dweebs back in the day. Your boy didn't know that. Let me know if you guys knew that in the chat. But essentially, Nerds, the company who owns the trademark for Nerds, they look at in 2024, this company made $800 million off of the candy Nerds. Man, you guys have to get to a product. You guys got to get to a service. Now, we all know that Nerds is a famous candy. I like Nerds. I'm actually, we all know that Halloween is coming up next month. And I typically take my daughter out trick-or-treating. And that's one of the candies that I look forward to confiscating from her. It's just, part of doing business. I'll take you trick-or-treating. I get a chance to eat some of the candy. And I always look forward to eating the Nerds, the little mini-sized Nerds, just because I don't typically eat candy, number one. I'm not going to the store and buying Nerds at this point, but around Halloween time, that's my one time a year that we get 2 or 3 of those mini Nerds and her Halloween candy, and I take them, and it's all part of the game. So let's pull up this lawsuit and go through it here really quickly. And again, let me know if you guys have comments or some questions as we're going through the lawsuit. But again, the company that owns Nerds is suing a company that just recently started selling the candy called Dweebs. And you guys may be interested, or it may be interesting to get my take on this one, because you guys I may disagree with this lawsuit here. So Ferrara Candy is the plaintiff, and they own the trademark for Nerds. They're suing American Continental, American Fizz, the distribution services, so forth and so on. We're going to call them collectively Dweebs. We're going to call that candy Dweebs. Now, I will say this. A lot of times, these companies that own these candies, whether it's Nerds, whether it's Kit Kat, whatever the case may be, it's like an umbrella company. So, as in this case, Ferrara Candy is the owner of a bunch of different candies. This seems like with this Nerd candy, they're making $800 million in 2024. So this is just last year. They made over $800 million just on a Nerd candy alone. Man, you guys have to get a product. That's what I'll say to that. You guys have to get a product. But let's go through this lawsuit here really quickly. I'm going to skip some of it, but we're going to hit the important parts. So Dweebs are a group of candy and snack product distributors poised to launch their Dweebs candy products across the U.S. As part of the campaign, Dweebs have engaged in knowing and willful false and misleading advertising regarding their Dweebs candy products and its connection with Ferrara, the Nerds family of products. Since first learning of Dweebs, Ferrara or Nerds has sent Dweebs essentially multiple cease and desist letters. As of this date, Dweebs continue their campaign to deceive customers. So essentially, Dweebs, they still selling the candy. Let's kind of move on to the heart of the case, the facts. So I'm going to call Ferrara Nerds, just so we all on the same page. So Nerds is recognized as a global leader in confections, and together with its related companies, makes distributes markets and sells through the U.S. numerous well-known and distinctive candy products, in this case, the famous Nerd brand. Following the success of Willy Wonka and the Chocolate Factory, which premiered in 1971, Nerd's predecessor introduced a series of candy products used various themes associated with the Willy Wonka character. Now, I do want to kind of stop here really quickly, because this is one of the things that people don't know. And this is the importance of building this brand and protecting a brand. Ferrara, they didn't start the Nerds candy. They end up buying that from, who did they buy it from? They're going to say it later down the line, but they bought that from somebody. So even if you have, start a company and you have multiple products, some products going to do good, some products not going to do good. However, if you protect the trademark, and this is why it's important to protect the brand name of these different products, because if that's a high selling product, even if the company goes down, somebody's probably going to still want to buy that product, that brand name, because it's valuable. And it seems like that's what happened. Ferrara ended up buying the Nerds brand name from somebody else. I think they kind of list that person, that company later down the line. But let's go. One of the Wonka themed candy products introduced by Ferrara's predecessors and interests is the Nerds candy product. just think all this happened based on a Willy Wonka film back in 1971. And I've never seen Willy Wonka and the Chocolate Factory. Obviously, it's a popular movie, but I've never seen it. So specifically, Nerds candy products were first introduced by Sunmark Corporation as part of its Willy Wonka brands in 1982. So Sunmark is the company that started Nerds, which ultimately Ferrara bought from Sunmark. So let's go here. The Willy Wonka brand division was subsequently acquired by Society, or essentially Nestle, and Ferrara and its related company ultimately acquired Nestle U.S. confectionery business. So Sunmark was bought by Nestle, and then Ferrara bought Nestle essentially, including iconic Nerds family products. So Ferrara and its related company also owned the exclusive right to use the Wonka brand in connection with this confectionery products. So again, as part of this sale, not only do they have Nerds, they got the Wonka brand, and I'm assuming that they got many other trademark brands with the purchase of this of the candy. Since its introduction in the 80s, the Nerds candy brand has achieved a numerous commercial success. Check this out, y'all. You guys have to check this out. This success is reflective by its extensive sales, totaling nearly $870 million in the U.S. in 2024 alone. So they made almost $900 million just based on the Nerds brand alone in 2024. That's crazy. These sales have been supported by significant marketing and promotion campaigns throughout the U.S., including Cali. Ferrara spent nearly $42 million in marketing and promoting the Nerds candy brand and the various products. So it spent $42 million. If you have to spend $42 million to make $870 million in sales, hey, I think you're doing good. The Nerds brand was first introduced in 1982 in association with Ferrara's novel candy product featuring small, irregularly shaped pieces of candy. So you see it here. And interestingly enough, Nerds, Ferrara or Sunmark, they actually got a trademark not only on the term Nerds, but they actually got a trademark or a trade dress on the shape of the Nerds, which you see here in this paragraph 28. The distinct varying and irregular pebble design of the original Nerds product is itself a registered trademark. So Nerds, the candy, those little Nerds, that's protected by way of a trade dress, which a lot of people don't know. You can get protected or trademark trade dress, which is a subset of a trademark law. You can protect the ornamental look and feel of it. So in this case, Ferrara actually has a trademark on not only the term Nerds, but they have a trademark on the candy, the actual pebble-looking candies, as you see here in this picture. The original Nerds product was an immediate success, winning Candy of the Year in 1985. So, they kind of did their thing. So, like I said, you got the trademark on the term Nerds. I'm not sure what these little things are, but this logo is also a trademark. So Ferrara is also well known for its iconic and distinctive dual color product packaging schemes, including the blow marks. So we all know when you have those kind of double color packaging, it seems like Ferrara also owns the trade dress or essentially the trademark on that as well. So again, they have a trademark on the term Nerds, on these kind of little characters, as well as kind of the packaging of the kind of one color or the two color packaging scheme. So they got a lot of trademarks on this stuff, man. Ferrara and its predecessors have long marketed, distributed, and sold candy and related products under the famous Nerd trademark, distinctive product packaging, and characteristic product designs. Ferrara marketed and sells several Nerd products throughout the U.S. and in this district. Representative images of the Nerd products are shown below. There you go there. 5 ounces is crazy work. Seems like they get the Nerd sticks. In addition to its extensive common law rights, Ferrara owns numerous federal registrations. I would say agree with that. In addition to the classic original Nerds, which kind of we see up here, they also have some other stuff that they own, including Nerds Drink Mix. Now, I've never heard of that. You guys have to let me know whether or not you tried the Nerds Drink Mix. Them Nerds Ropes, hey, that stuff fire. I have had the Nerds Ropes before. Those are pretty good. And the Big Chewy Nerds. I think I've had those before. I guess they have some baby Nerds as well. They got a lot of trademarks, man. As a result of Ferrara's extensive use and promotion of the Nerds marks and Nerds family of products, consumers have come to associate the famous Nerds marks. I would probably agree with that. It looked like Nicki Minaj as well as Lil Wayne like nerds. That's what it says here in paragraph 39. From its Willy Wonka origins to recent collaborations and testimonials from celebrities such as Kylie Jenner, Nicki Minaj, and Lil Wayne, the nerd brand is iconic. Seems like you see your boy Lil Wayne in the back, Nicki Minaj. So let's go to the origin of Dweebs. In 1988, Ferraro's predecessor in interest introduced the Dweebs candy. So some Mark who started Nerds also owned a Dweebs candy, which I guess they call it the cousin of Nerds. And these are the Dweeb. This is the Dweeb packaging. Now, I'm familiar with the Nerds, and I grew up in the 90s, but I am not familiar with the Dweebs candy. And it seems like this came out in the 90s. The Dweebs products were discontinued, or it was discontinued in the 90s, I should say. To date, as a result of the tremendous popularity of Dweebs candy product, due to its strong association with the Nerds family of products, the Dweebs brand continues to enjoy extensive goodwill and is still associated with the Ferraro and famous nerd marks. So this is what I would have to disagree with Nerds and Ferraro in this case. This Dweebs candy was so popular, number one, why was it discontinued in the late 90s? We had 2025. So this means that this candy has been discontinued for 25 years, yet you're saying that it's a popular candy. I think that's BS. I definitely think that's BS. The fact that they're saying that this Dweebs candy was, what they say, tremendously popular, even though it was discontinued in the 90s. I think that was some BS. And it said defendant seeks to usurp and trade on the fame and goodwill of the Nerds mark and existing goodwill of the Dweebs. And I also say, if this thing was so famous, why let the trademark go? I'm assuming at some point you had the trademark for the term Dweebs. Why, even though the candy was discontinued, why let the trademark go? Because you can always, you can stop selling something and still keep the trademark in case you want to kind of bring it back up. You guys, to the extent that you had the trademark Nerds and Ferraro or some mark, you guys let the trademark go. So that means anybody can pick up the trademark for the term Dweebs. And it seems like in this case, the defendant actually trademarked the term Dweebs. So that's why I don't understand if kind of some mark of Ferrero, as if this trademark D's or this candy was so popular, why number one, discontinue the candy? Then number two, why let the trademark go? Those are some of my thoughts as I kind of think about this. But let's go to the defendant's unauthorized conduct. So long after Ferraro and his predecessors first used the Nerds mark, this family of product, the defendants have adopted and are using the confusingly similar Dweebs mark in connection with the marketing, sale, and distribution of identical candy products. What they missed to say is the defendant actually has a trademark on the term Dweebs. They got the trademark on the term Dweebs. So upon information and belief, defendants were aware of the popularity of the Ferraro Nerds mark and continued goodwill in the Dweebs mark. Indeed, upon information and belief, the defendants also distribute several Nerds candy products and thus were aware of Ferraro's rights in the Nerds mark. Based on their own marketing, including through his Dweebs website, defendants intend to trade on the goodwill. So I will say this. I'm okay with you having the term Dweebs trademark, but when you put them in that packaging that we all know for the Nerds packaging to be in, that's kind of where it gets a little dicey for me. I'm cool with you using a Dweebs mark, but it does look like the defendant, you're trying to trade off the goodwill of the Nerds when you put them in that similar, that two-tone packaging. I think that's kind of where you get a little, what's the name? You can kind of see it. It looks similar. Even though the name is different, obviously Nerds is different from Dweebs, and the defendant has a trademark on the term Dweebs. When you kind of put it in that two-tone packaging, you guys have to let me know. Let me know in a chat. Do you think that these are similar? Would you, if you're going to the store to get your Nerds and you see this Dweebs, would you think that this is Nerd candy? You guys have to let me know this. The logo is different. Again, I'm not sure what these things are, but the Dweebs have, like in this case, a watermelon and a cherry. The name is different, Nerds and Dweebs, but that two-tone packaging kind of is where it gets a little dicey for me. I still think it's Dweebs have some arguments but that just doesn't help them out. And it really doesn't help Dweebs out the fact that the candy looks the same. So again, the name is different. Kind of the logo on the box is different, even though the two-tone box are very similar, but the candy is similar. This is a tough one for me, I must admit. I would probably say that given the fact that Dweebs deal with the two-tone packaging and the little pebbles, which they're definitely committed trademark infringement or trade dress infringement by using pebbles, which Nerds has trademarked. The fact that you did all that with the packaging, that kind of lets me believe that you guys were doing some illegal or illicit things. Further, the product and configuration, the Dweebs product is nearly identical to the product configuration of the original Nerds product. It looks close. As demonstrated above, the finish had blatantly adopted numerous elements of Ferraric iconic nerd marks. Definitely the packaging as well as the candy itself is similar. Now the name is different, Nerds and Dweebs, and the logo on the packaging is different, but it kind of, I don't know. I think Dweebs didn't help them out in this case. I'm not sure what this is about. I see some Oreos over here, some bubble gum. The Dweebs candy over here. So unsurprisingly, the relevant consumer public is keenly aware of the false association between Dweebs and Ferrera. Since first learning of defendants, or essentially the Dweebs mark in the UK and Europe, seems like Ferrera has sent the defendant cease and desist letters, trying to negotiate in good faith. Ferrera has also filed oppositions in the UK against applications by the defendant to register the marks. Y'all should have been doing that in the U.S. because they got the trademark, the marks registered in the U.S. Despite Ferrera's attempt at good faith discussions and notwithstanding defendants' knowledge of Ferrera's rights, defendants have continued to expand upon their infringing activities. Seems like there were some expos. See the Dweebs at some expos. They got to try to sell that product. So upon information to believe since at least May of 2025, defendants infringing Dweebs products are now available. So now Dweebs selling them joints in the U.S. So you can pick the Dweebs. If you go to dweebs.com, I think you can pick them up. So there's no question that defendants marketing the sale of the Dweebs product is willful and in callous disregard of the Ferrera's rights. Defendants' use of the Dweebs mark and Dweebs product packaging is likely to deceive, cause confusion, and mistake in the minds of the purchasing public, and in particular, to and does falsely create the impression defendants' goods are produced by or in association with Ferrera. Defendants are intentionally trying to usurp the existing and residual goodwill and secondary meaning of the Dweebs mark by falsely suggesting a connection to Ferrera's family of candy products. Indeed, defendants' website specifically states Dweebs are the fruity, tangy candy inspired by the bold, intensive flavors of the USA. Given defendants' use of a confusingly similar trademark and product packaging in connection with identical goods as those offered by Ferrera, and in light of the defendant's refusal to accede to Ferrera's repeated requests and demands to cease, pretty much they're trying to say it's a trademark infringement. Now I would say this ultimately. Ferrera, or some mark I should say, y'all didn't do yourselves any justice by, number one, discontinuing something that I would imagine that you discontinued because it wasn't selling and letting the trademark go. But then later down the line, trying to say that they're trying to trade off the goodwill of the Dweebs trademark. You guys don't own a trademark anymore. In fact, to the extent that you did have one, you let it go, and the defendant picked up the Dweebs trademark. So again, I don't know how you kind of square that hole. Then I will say to your guys' point, Ferrera and Nerds, it does look like Dweeb tried to kind of trade off your goodwill. Now the name Dweeb and Nerds is different. Now, the logo on the packaging looks a little different, but that two-tone packaging, we all know that's a Nerds. That's a nerd trademark, so to speak. And obviously the fact that they have a trademark on those pebble candies, which you guys are using as well. I think the original Dweebs candy was like a soft, chewy thing, slightly larger in size from my understanding. So it does look like Dweeb is without fault. Hopefully you guys settle, because I can see this one going either way. I can see that the jury or the judge coming out in favor of Nerds because of all the bad intent that Dweebs did, but at the same time, between the name and kind of the logos on the packaging, maybe it's a small chance that Dweebs come out in favor on top in the trademark infringement lawsuit. So that's kind of my take on this thing. I think it's a toss-up. Hopefully these two parties settle. I think it was kind of wrongdoing I won't say wrongdoing on both sides, but I do think that Dweebs tried to kind of trade off the goodwill of the Nerds candy and the logo and the box and whatnot. But I do think that Ferrera and its predecessor some Mark didn't help himself out by essentially letting that trademark Dweebs go. So those are my 2 cents on this one. I would love to hear your guys' 2 cents in the comment section. So please let me know what you guys think in the comment section. Let's see here. What else do we have here? I think that's pretty much it. We're coming up on an hour. So again, thanks again for tuning in to another live episode. I'm going to go check out this Baltimore Buffalo game. Hope you guys enjoyed this one. Please hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community. And I'll catch you guys next time. Peace.